Welcome to the deep dive. Today, we're looking at something really fundamental in contract law, a distinction that sounds small but has huge consequences. We're talking about the difference between a condition and a covenant, basically, a promise. And why does it matter? Because it determines everything about what happens if someone breaks the deal.
Yeah, it's the first question you ask. Was it just a broken promise where you can sue for money? Or was it something bigger, a condition where the whole contract might just evaporate and you could lose the property involved? That's forfeiture. We're going to unpack this using a classic case, Hale v. Finch from 1878. It involves a steamboat, and it really shows how courts dissect the exact words parties use to figure this out.
Exactly. And dissect is the right word. We want to show you the kind of rigorous analysis courts use, especially when forfeiture is on the table. It's a pretty extreme remedy. So we'll start with the basic rules, the definitions. Then we'll use that Hale v. Finch case, but we'll do it step by step, element by element, just like the court did, to see how they reach their conclusion based purely on the contract's language. Okay, sounds good. Let's start with those basics then. Before we get into the steamboat story, can you just lay out the fundamental legal definitions? What really separates a condition from a covenant when we're talking about enforcement and, well, the final outcome?
Sure. So a covenant is essentially a promise within the contract. Someone agrees to do something or not do something. If they break that promise, breach the covenant, they've created a personal liability. The other party can sue them personally for money damages to compensate for the harm caused by the breach. Usually the contract itself still stands.
Okay, so covenant equals promise equals potential lawsuit for damages. Got it. What about a condition?
A condition is different. It's not really a promise to do something. It's more like an event, something that has to happen, or maybe not happen, before the main obligations of the contract even kick in. If an express condition isn't met, it doesn't automatically mean someone owes damages personally. Instead, the failure of the condition often means the contract obligations are excused or the whole contract might terminate. It can lead to forfeiture, losing the thing you contracted for.
Right, so the outcome is drastically different. Damages versus potentially losing the whole deal, the forfeiture you mentioned. Is there like a policy preference? Do courts lean one way if the contract language isn't crystal clear?
Oh, absolutely. Courts generally dislike forfeiture. It's seen as a very harsh result, right? Losing the entire benefit of your bargain.
Yeah.
So if the language in the contract is ambiguous, if it's unclear whether something is a condition or a covenant, courts usually lean towards interpreting it as a covenant. That way, the remedy is just damages, which is less severe. They try to avoid forfeiture if they can.
But only if it's ambiguous.
Exactly. And that's the key point Hale v. Finch hammers home. If the parties use really clear, explicit language indicating a condition, the court's preference doesn't matter as much. They feel bound by the words the parties chose.
Okay, that sets the stage perfectly. Let's analyze Hale v. Finch. First, can you lay out the legally dispositive facts? What actually happened?
Right. So the plaintiffs, Hale and some others, sold a steamboat, the New World, to the defendant, Finch. This was done through a formal bill of sale. Now, critically, this bill of sale included a specific clause. It said the sale was, and this is the exact wording, upon this express condition.
Express condition.
Okay. And the condition was that the boat and its machinery couldn't be used on certain river routes, specifically California or Columbia River routes, for a period of 10 years. Seems like they wanted to limit competition.
Makes sense. So what happened?
Well, Finch apparently did run the boat on those routes, breaching the clause. So Hale and the others sued Finch. But here's the crucial part. They sued him for personal damages, assuming the clause was a covenant, just a broken promise.
So they didn't ask for the boat back?
No, they asked for money damages. The trial court, however, didn't agree with their interpretation and told the jury to fine for the defendant, Finch.
Interesting. A big asset, a steamboat in 1878, that's major. So given those facts, what was the core legal issue the higher court had to decide?
The precise legal question was this. Was that clause restricting the boat's routes a covenant, meaning the plaintiffs could get damages from Finch personally? Or was it strictly a condition, meaning their only remedy was to try and get the boat back through forfeiture? Okay, the classification is everything. So what rule of law did the court use to make that decision? Can you state the rule and maybe break down its key parts, the elements the court looked for?
Yeah, the court applied a rule rooted in strict interpretation of the contract text. Essentially, the rule is, if words in a contract clearly indicate they mean only a condition, and there aren't other words muddying the waters or making the meaning doubtful, then those words must be interpreted as creating a condition.
So clear words win, pretty much. And to apply this, the court looked for three main things, like a test. First, explicit textual intent. Did the parties use clear, strong language like express condition? Second, lack of ambiguity. Was the language confusing? Were there other clauses that contradicted it, or was it perfectly clear? And third, absence of extraordinary facts. Was there any claim of things like mistake or being forced into the contract, or maybe someone not having the mental capacity, things that might undermine the agreement itself?
Thank you. That's very clear. Now for the court's elemental analysis. Let's walk through this step by step, just like you said. How did the court apply that first element, the explicit textual intent? That seems like the heart of it.
It really was. The court zeroed in on that exact phrase. It is understood and agreed that this sale is upon this express condition. They basically said, look, when parties go out of their way to use language that's specific and emphatic, they clearly mean it. They called it conspicuously one, meaning conspicuously a condition. The court felt it had to give those powerful words their plain, ordinary meaning. They saw it as clear evidence of what the parties intended right there in the text.
It sounds like using express condition was almost legally fatal to the plaintiff's claim for damages. But couldn't the court have looked for a way out? Maybe find some ambiguity? How did they handle the second element, the lack of ambiguity or qualifying words?
Right, you'd think they might try, given the preference against forfeiture.
Right.
But here the court found the contract was actually very well drafted. They described it as drawn with care, skill, and intelligence.
High praise.
Indeed. And because it was so well drafted, they found no ambiguity at all. The language restricting the boat's use was clear, the express condition part was clear, and there were no other parts of the contract that seemed to contradict it or suggest it was just a promise. They even mentioned that the legal precedents, the books, were all one way on this. When the text is this explicit, you follow the text. So no wiggle room found there.
Wow. So the careful drafting actually worked against the plaintiffs suing for damages. Okay, what about the third element, the absence of extraordinary facts? You said things like mistake or duress. Why did the court even address that if it wasn't really argued by the plaintiffs?
That's a good question. It serves as a sort of backstop or foundation for relying so heavily on the text. The court basically says, we will enforce these explicit words unless there's a reason to believe the agreement itself wasn't freely and fairly made. So if the plaintiffs had claimed, say, they made a mistake in using those words, or they were pressured, the court might have looked beyond the literal text. But since no such claims were made, no mistake, no duress, no imbecility, as the court quaintly put it, the court had to assume the parties knew exactly what they were doing when they chose those words. It validates the focus on the text in the first two elements.
Okay, that makes sense. It closes off potential loopholes. So after analyzing all three elements, the super clear text, the lack of any ambiguity, and no funny business in how the contract was made, what was the court's final conclusion?
The court's conclusion was firm. Based on that textual analysis, the clause was undeniably a condition, not a covenant. And because it was a condition, the plaintiffs had sued for the wrong thing. They asked for personal damages against Finch, but the only remedy available for breaching this kind of express condition was forfeiture going after the steamboat itself. So the judgment of the lower court, which was in favor of the defendant Finch, was affirmed. The plaintiffs lost because they fundamentally misunderstood or mischaracterized the nature of their own contract clause when they filed the lawsuit.
They asked for the wrong remedy entirely. That's harsh. Okay, let's make this super concrete. That difference in remedy damages versus forfeiture is huge. Can we use a quick hypothetical? Imagine selling, I don't know, a really rare, valuable painting. If the contract says the sale is upon the express condition, it's never loaned to a specific rival gallery, versus a clause where the buyer just covenants or promises not to loan it there. What's the difference if they break the rule?
It's a perfect illustration. The difference is massive. Let's take the covenant first. The buyer promises not to loan it to the rival gallery. If they break that promise, you, the seller, can sue them for damages. Maybe the loan diminished the painting's prestige or affected the market value of your other works. You try to calculate that financial harm and get a check from the buyer. But critically, the buyer keeps the painting.
Okay, money changes hands, buyer keeps the art. Now, the condition scenario.
Now, if the contract says the sale is upon the express condition, it's not loaned there, and the buyer loans it anyway. That's Hale v. Finch territory. The condition is broken. That doesn't just create a right to sue for damages. It triggers the potential for forfeiture. The failure of the condition could void the original sale, meaning you, the seller, could potentially demand the entire painting back. The buyer loses the asset completely.
Wow. So one phrasing leads to getting a check, the other leads to getting the whole painting back. That really drives home the power of that express condition language.
Precisely. It shifts the consequence from monetary compensation to the potential total loss of the property. Huge difference.
Okay, this has been incredibly clear. For everyone listening, especially if you're dealing with contracts or studying law, let's try to synthesize this. Based on Hale v. Finch in our discussion, can you provide a sort of checklist, an analytical framework for figuring out if a clause is a condition or a covenant?
Absolutely. Think of it as a diagnostic tool when you're looking at a contract clause.
Yeah.
Step 1, spot the language. Look closely at the words used.
Mhm.
Is it mandatory, condition-type language? Phrases like, on condition that, provided that if, or the really strong one, upon this express condition. Or is it promissory language, like agrees to, promises to, covenants? That's your first clue.
Okay, language first.
Step 2, test for ambiguity. How clear is that language? Is it explicit and unambiguous like in Hale? If yes, you generally have to follow the text unless there are those extraordinary circumstances we talked about, mistake, duress, etc. But if the language is ambiguous, or maybe conflicts with other parts of the contract, then the court is likely to lean towards interpreting it as a covenant to avoid that harsh forfeiture remedy.
Check for clarity. Default to covenant if it's fuzzy. Got it.
Step 3, determine legal effect. Once you've classified it, pin down the consequence. If it's a condition, breach means the obligation might be excused, the contract could terminate, and forfeiture or getting the property back is the likely remedy. If it's a covenant, breach means the performance is still technically owed, but the failure leads to personal liability for money damages. The contract itself usually survives.
Condition and termination forfeiture risk. Covenant equals damages.
Step 4, match remedy to violation. This was the plaintiff's downfall in Hale. Make sure the legal action matches the classification. If it's a condition, seeking only personal damages is the wrong path. You need to seek the remedy appropriate for a condition failure, like forfeiture. If it's a covenant, you sue for damages. Asking for the wrong thing can doom your case from the start.
That's a fantastic practical checklist. So, the big takeaway from our deep dive today seems crystal clear. Words matter immensely. Choosing between condition and covenant isn't just about style. It fundamentally dictates whether a breach leads to a monetary payout or potentially the complete unraveling of the deal. Hale v. Finch is a stark lesson in the power of explicit contract language.
It really is. And it leaves us with a lingering policy question, doesn't it? We see how severe forfeiture can be, especially with high-value assets like that steamboat or your hypothetical painting. Given that severity, maybe modern courts should be even more cautious. Perhaps they should require stronger proof that parties truly understood the drastic consequence of using express condition language, especially compared to just promising something. It's that constant tension between respecting the party's written words and ensuring a fair, commercially reasonable outcome. Something to think about.